Thank you. Please stand by. You will now be placed into conference.
Court is addressed, access and visitation to the children is all addressed in a court. And so people are very aware that they've got a child support order and they've got a child support case, and that's well and good. But with the unwed population, which continues to grow, it becomes more problematic because these couples have an informal kind of situation. They may not establish paternity, and by that I mean they may or may not take the legal steps to ensure that the child has a legal father. As these couples break up, then there's no real way to keep father associated with the child. And so mother may be alone with the child for a while, and then she decides, oh, you know what, I need child support. But by that time, the father is so far gone that no one knows where he is or doesn't know how to find him. Another likely scenario is that mother goes by TANF or Medicaid. Those are automatic referrals to child support. So if she goes in and applies for TANF, child support is going to open a case automatically on that case. And so again, if they don't know where the father is and they can't find the father, a lot of this action happens behind the scenes, and child support orders are set up by default, and so forth. So it's not that unusual for people not to know that they have a case. So if you, there are things that there are things that you might ask when you're trying to learn if there's a child support case, if you're working with a low-income individual or somebody in the reentry world. You can ask if he knows that he has a case, and if he has a case, try to get as much information as you can. Try to get the case number, the child support agency where the case is. Those are some key elements. Try to get names, birth dates, children, social security numbers, case identifiers. All of those are very useful. Try to get as much case information as you can. That way you'll be able to assist him with his case. More things to ask, to determine if there's a child support case. If the parent knows he has children but doesn't know that he has a case, but you might have a hunch, you can contact the state child support agency in the state where the mother and the children live. And if the parent doesn't know the state where the mother and the children live, you're going to have to work with your local child support agency. You're going to have to do this for every case that a parent might have. He might have more than one child with, one or more women. So you might get one child support matter cleared up only to find out that there's another one lurking behind. So you have to try to get as much information as you can. I think Layla's going to be able to give you much more of this where the rubber hits the road kind of information toward the end slide. Sometimes you'll find out that there's a child support case where you least expect it. Some parents will learn that they have a child support order when they get a credit report. And child support arrearage is something that is reported to credit agencies. So believe it or not, some people stumble upon the fact that they owe child support by simply requesting a credit report. And I know that this can sometimes be difficult to clear up, especially when people are trying to gain a foothold again in the work world.
Karen, let me interrupt you if I apologize for that.
Sure.
For those who've just joined us, you're able to mute your phone, use a mute button, and use *6 if you don't have a mute button, and try that. I hear some typing in the background. It comes through to all our phones, so if you could refrain from that or at least somehow mute your phone, that would be really appreciated. Karen, I'm sorry for the interruption. Please go ahead.
That's all right. And others learn about their cases when they have a bank account. Say they'll set up a bank account, and they'll suddenly find it seized and money taken out of it, or they'll find out that their driver's license has been suspended. These are all things that can occur in the background. Getting back to, this idea that they don't know why the order got so high, again, it all goes back to the way that child support orders are set up. First of all, to have a child support order, paternity has to be established. If there's no paternity established, you can't establish a child support order. So child support may be looking for someone so that they can establish paternity and make him the legal father and financially responsible for a child. The orders, on the other hand, are something a little bit different in that they can be set up without really having the father present. And I mean that legal steps are taken. There is sort of a process, but if paternity is established, they can make a child support order without his participation. States have a set of guidelines that help them determine what the child support order amount should be. And every state has to have these set of guidelines, and they have to be reviewed every 4 years to make sure that they reflect financial situations that are going on. But if a child support agency learns about employment through quarterly wage data, they'll go ahead and set an order based on that. Or if the mother says, well, you know, he used to be a bricklayer, the judge might very well say, well, what does a bricklayer make here in Virginia? Like $9 an hour and 40 hours a week. So you can see how they can become pretty unrealistic very quickly. Other times states will say, well, we're going to base the order based on minimum wage, 40 hours a week. Again, we know that the population that you're working with, this is not always realistic, and the orders come out very high. Slide. So fact number 2, if a parent has a child support order, the obligation does not go away automatically if the parent is unemployed or is incarcerated. The arrearage adds up quickly, and many states also charge interest. Layla, I think, will cover more of this in her presentation. But I think what happens, especially in the area of incarceration, where somebody had been working and child support had been withheld automatically from their paycheck, when someone is incarcerated, I think they just assume because so much is done automatically that we automatically know that he's been incarcerated and is not able to work anymore. That is not the case. Many states are just beginning to have rudimentary kinds of data exchanges with jails and their Department of Corrections. So that's another reason why the arrearage will just start to rack up. Slide. And steps you can take to address the amounting arrearage. So now that he's in reentry, he's out of prison, that order is still going to continue to mount up at that order amount that was set. So you need to find out how much the order is for and how much of the arrearage has accumulated, and using the same steps, trying to find out as much as you can about his case to get it back in order. The parent is going to have to request downward modification for the order or the orders that he has. And you're going to have to do this, or he's going to have to do this, for every child support order that he is party to. And forgive me if I'm defaulting to he and father. That's the majority of our cases, and just easier than trying to trip over he, she, and mother, father. But obviously, either parent can have a child support order. Slide. If the child support order is in another state, then the Uniform Interstate Family Support Act, or UIFSA, rules apply. States have procedures to accommodate child support matters that involve 2 or more states. This is very complex, and I'm not going to sugarcoat it and say that interstate cases are easy. They often are not, but there are steps that child support agencies are taking to facilitate this kind of communication. There's a child support network that's been in existence for many years that allows states to exchange simple transactions with each other. And in addition, there is a new project underway on a national basis that's going to allow caseworkers to actually query the case management systems in another state to get the most recent data in real time. So there are efforts underway. We are aware of how difficult interstate can be, and people are working on this all the time. Slide. Will the debt be forgiven? If the mother receives or received public assistance such as TANF, Medicaid, or foster care services, child support that is collected will be used to reimburse the state. Some states have the statutory authority to forgive some of this debt, but others do not. And we know that mothers and fathers who pay child support are not keen about seeing the bulk of their payments go to reimburse the state for TANF or Medicaid or foster care. Some states will forgive that debt owed to the state and will allow much or most of the child support to go directly to the family. And in addition, the Deficit Reduction Act of 2005 changed many of these very complex child support distribution laws that we have. So the ultimate goal is to get more money to the family. Slide. Debts owed to the mother, though. That's a different kind of situation. The child support agency or courts cannot forgive past owed debt owed to the mother without her consent. This is known as the Bradley Amendment. And you should know that many mothers will agree to reducing past debt if payments can be regularly made. We're having a lot of success with this involving Reentry in Milwaukee. I think they found something like 30% of the moms were more than willing to forgive a lot of the debt that was owed to them. They just wanted to see the dad get back on track and begin to make regular payments. But there was a good reason for the Bradley Amendment, as I was telling Layla the other day, that in the early days of child support, when we weren't so automated, we couldn't find people, this child support debt would accrue, and we'd finally find the obligor, and we'd get him in the court, and the judge would say, well, that's too much. You can't be expected to pay that. Let's just forget all that and start off fresh, and you pay $50 from now on. Well, you know, in the meantime, then he would just leave and go and buy houses, and the families were left without anything. And so that's why the Bradley Amendment said, you can't forgive that past debt. That debt is owed to the mother, and so we're kind of locked in now because of that in many ways. Slide. Child support will often work with parents who owe large arrearages. Child support performance is measured on how many cases receive payments. It's not on how much money we collect. We do collect something like $24 billion a year, but that's not how our performance is measured. It's measured on how many cases we collect on. So many child support agencies will work with a parent to create a payment plan, and some will forgive debt and interest if the payments are made regularly. In other words, it's in the best interest of a child support agency. It improves their performance. If they can get more cases to pay a small amount, then they can get fewer cases to pay a large amount.
Karen,
yeah,
Stephen asked a question. He says, can you tell us some of the conditional programs for arrearage forgiveness, such as having the payer spouse hold a job for 6 months? Do you know about these?
I do, and Layla's actually going to cover what Maryland has done, and I think what Maryland has done is pretty. I wouldn't say, I would say it's typical. It's a very, so we'll go through that. But they do vary from state to state. You need to know that some states still view incarceration as voluntary unemployment, and they will not cut a special deal for anybody who's been incarcerated.
Like Virginia.
Yeah, and some others. But again, they have to have the statutory authority to forgive that debt. There was one state that started, forgiving debt, and they got slammed down and said, wait a minute, you don't have the authority to do that. So it does require statutory authority. But Layla, I think, will cover a nice program that Maryland has. And I do have some information about what states are doing state by state. So at the end, take a look at my contact information, and I'll see about sharing it. Or if I can't share that document with you, it's in draft form, I can at least talk to you a little bit about what's going on in your state. Let's go to fact number 3. That child support has large, powerful systems that include many, many automated functions. And these systems rely heavily on national employment-related information, such as new hire reports and quarterly wage data. Slide. This is something that a lot of people don't know, but the Federal Office of Child Support Enforcement houses all the quarterly wage data in the country. We also have a federal case registry, which contains millions and millions of child support cases and orders. And these two databases are constantly matching and sending data to the states involved. So that this was set up in 1996 as part of PERORA, so that if Kansas and Missouri are both looking for the same obligor. As soon as he gets a job, Kansas and Missouri are going to get data saying, you know, he's got a job, and you know what, Missouri? Kansas is looking for him, and you know what, Kansas? Missouri's looking for him. And that idea is so that states will get on the phone and start working these cases together. To find parents if they're not in quarterly wage, and many people are not, other databases that child support uses to locate parents include matches that we conduct with the Department of Defense, Veterans Affairs, Internal Revenue Service, Federal Bureau of Investigation, the National Security Agency, and the Social Security Administration. So there are lots of big matches going on all the time. Slide. The states conduct similar matches. States match their own employment data with their child support caseload. They also match with other in-state databases for locating people, typically Department of Motor Vehicles, but some others have other things arranged with other big databases around the state, and that can vary. As in the federal system, jobs that have quarterly wages are found readily. So, you know, it's our goal to see people have above-ground legal employment, but if they're going to be found and child support is garnished right away, we know that this can be a disincentive and they may go underground. So that's why it's critical that when a child support issue is discovered, let's try to get to the bottom of it. Like, the employer receives notice to begin garnishing wages when a quarterly wage matches with a child support case. An income withholding order is automatically sent to the employer, and the employer must garnish the wages or face serious penalties. Garnishments are subject to the Consumer Credit Protection Act limits of 50 to 65% of the paycheck. This can be a tremendous amount of money coming out of a small paycheck or a large paycheck, especially if the order was set too high. I just want to say a few words on employers, and many of you may be working with small employers who are not that familiar with child support matters, especially income withholding orders. Please note that all child support agencies in the country, all state offices, have staff that's dedicated to working with employers. And they offer training and other kinds of support for these employers. Some of them even have dedicated 800 lines for employers. So if you're encountering a situation where the employer is withholding too much, by all means, try to get that taken care of right away. And on the back slide, I'll give you a website where you can go to where you can see how child support is supposed to be calculated. You should also know, too, that there is a federal law that says someone cannot fire somebody or cannot not hire somebody because the individual has a child support matter. Of course, that's difficult to prove, but again, our desire is to work well with employers. Slide.
Karen, there's a question. Maybe it would be a good time. Stephen, are you able to unmute and ask your question?
Can you hear me?
Yes.
Sure can. Go ahead.
Oh, hello. My question, well, two questions, both related to the CCPA and the withholding. Is there a limit on multiple child support orders? In other words, if one child support agency says, well, we can get 50% of this paycheck based on a wage withholding order, but another child support agency from another county or another state sends out a withholding order that says, we want 50%.
Yeah.
What happens in that situation?
There is a way, there is information on our website that will tell an employer what to do when he's got two orders coming in from a different state and how to allocate across those orders.
Okay.
I believe it's there, Stephen. If it's not,
and I'm sorry, I missed your website at the beginning of this.
Oh, I'm going to have it at the last slide.
Okay.
And Drew will be getting the slides out to you. But it's basically if you can take up to 50% of the paycheck for one order if it's current, 55% for one order if it's in arrears, 60% for two orders if they're current, and 65% if both orders are in arrears.
Okay.
So it's quite a it's tangled. I mean, it's really Yeah, it is. And then but there should be no instances where somebody's getting $1 in their paycheck. Is what I'm trying to say. And I'd be happy to work with you to get you to the right resources to get things like that resolved.
Thank you.
I want to get through this because as Layla's going to, I've only got a couple more. Slides. Something I would recommend that you do if you're working in reentry, again, many child support agencies are very interested in working with obligors. We're recognizing the role that incarceration is playing in child support. Some child support agencies will say that 3, 5, up to 10% of the child support caseload is incarcerated. States are able to say things like, 30% of our obligors are not paying their child support because they were formerly incarcerated. So incarceration, we're coming to realize, is playing a big role in our ability to collect child support so the kids get support. But there's also a growing realization that that it's important to keep families to support men as well as women in this whole family kind of dynamic. So one of the best things you can do is go to your local child support agency, try to establish a working relationship with them. Many times they like the idea of being able to be part of the problem solving, and I hope I'm not wrong about that, but that's certainly the sense we get from the emails that we're hearing from around the country. But it's important that when you're working with these parents, if they lose a job or anything like that, have them get in touch with a child support agency right away. And the last fact 4, is that states and local child support policies vary in how they address persons with barriers to employment. I told you earlier that some will view incarceration as voluntary unemployment. Some will, there is a sense that people stay underemployed. There's this real desire to get out there and make sure people are working as hard as they can for their kids. So, and that will vary from state to state. So it's important that you learn about your local child support agency and how you work with them. I'm going to stop here because I took way too much time. And Layla, and then that last slide is on our website. And that has things in there, again, about those federal systems I told you about, how you find people. There's information on employers there. There's publications that we have. A lot of them are in Spanish. There's a nice glossary of child support terms that's available. There's links to different states so you can see how they're set up. There's contact information. And there's also information on there on access and visitation, and I didn't really talk about that, but I know that's a huge issue. If you have parents who say that they're paying their child support or they don't get to see their kids, there are grant monies available to help in those kinds of situations. So the last slide has my contact information. I'd be happy to hear from you. I love the work you guys are doing. Again, anything we can do to help. So thanks, and I'll turn this over to Layla.
Well, let me thank you, Karen. This is Drew Carberry with the National Crime Prevention Council again. I'm hosting the webinar today. Thanks, Karen, very much. We have a couple questions outstanding. Maybe you can give a brief answer right now, Karen.
Sure.
The first question is from, let me back it up. Francesca wanted to know, what if the orders are in the same state, but one is based on divorce and one is based on Child Support Bureau? Do you have a response to that?
There really shouldn't be much of a difference. Most states will view the children, that would just be another child support order. What that father gets with the divorce setting, though, is he has parental rights and has access and visitation rights to that child. For his out-of-wedlock child, however, he does not. He will be required to pay child support just as if that child had been born inside of wedlock. So I guess the best message here is, have your kids inside of wedlock. That's the fathers really have more. They have more rights to the child, and it's there's a legal framework when people get married that children are born into, and when they're born outside of wedlock, you have to try to recreate that kind of legal framework, both financially and emotionally.
Thanks. Is there one more quick question for Karen? Karen's going to be available towards the end of our hour for for more questions. But if you have something, a quick clarifying question, please unmute and ask it now.
How often is the earnings thing updated? I know it says quarterly, but how far behind is it, Karen?
I think it's 1 quarter behind.
Okay.
I think give them a quarter to get their data together and a quarter to get it up there, so it's often a little bit behind.
Do you find that most states keep up with this, or are many behind?
They're really monitored closely to make sure that they're submitting on time.
Okay.
Thanks for the questions. We're gonna go to Layla now. Layla D'Ambrosio is an attorney, and she works with the Legal Aid Bureau out of Baltimore, and she's going to fill us in on sort of the day-to-day nuts and bolts of working with clients and people seeking child support, and we'll go from there. Layla, are you available?
Yes.
Hi, Layla.
Hi. Hi. Good afternoon, everyone. Before I start, I just wanted to make sure and clear to everyone that what I will be talking about is specific to Maryland. As Karen has said before, child support does vary from state to state. But some things tend to be more or less the same across the nation. So hopefully this will be of some help to all of you. So for the Legal Aid Bureau, I mostly deal with non-custodial parents who are confronted with child support payments and arrears that they cannot pay for a variety of reasons. So I help them try to settle things down a little bit for them. I come across 5 major areas, and those are listed here on the slide. I help them to modify an order because the parent is incarcerated or is unemployed, or has currently has custody of the child who is the subject of the child support order. I also help them with reinstating their driver's licenses because in Maryland, as I will say in further detail later on, if the parent is more than 60 days late in child support payments, the license can be suspended. Also, the low-income population that we deal here, especially in Baltimore City, frequently they're transient. So notices that the court send out to the parents often are sent out to the wrong address, so the parent does not receive a notice, does not appear in court for a hearing, and then a warrant will be issued out against them. So I also help them with quashing these warrants. And last but not least, probably the biggest chunk of my time is devoted to working out with a local child support enforcement agency and trying to see if they're willing to work with me and the non-custodial parent and reduce the amount of state-owed child support arrears. Slide, please. In Maryland, child support cannot be modified retroactively. That means that the court can only modify a child support order from the time the parent files a motion to modify. They cannot go before in time. So that is why it's absolutely vital that people know that they have the right to file a motion to modify as soon as there is a significant change in circumstances, which in Maryland means there is a 25% change or more in their income. So that obviously when a parent is incarcerated, that's a significant change in income, and basically goes down to 0. So they must immediately file a motion to modify child support and have the obligation suspended until the release from incarceration. The problem is that many people, or I'd say the majority, do not know about this. So they do not file when they get incarcerated, and once they come out of incarceration, they find themselves hit with tens of thousands of dollars in child support debt. So that is one area that I think is absolutely critical for this state and the nation in general to resolve. And then equally, if the non-custodial parent is unemployed, the same thing, he or she must file a motion to modify the child support and reduce it back to an amount that he or she is effectively able to pay. Again, whenever a motion to modify is filed, it has to be done as soon as the change occurs. Next slide, please. And that is why also when the parent, the non-custodial parent, regains custody of the child, that's the same thing. He or she must go to the court and file a motion to modify based on retroactive custody. This must be done as soon as the parent regains custody of the child that is the subject of the order. This may happen because the other parent may have problems of his or her own, and gives the child to the other parent temporarily or many times permanently. And this happens very frequently. I've come across many people that have their child living with them and still have child support orders out against them.
Yep.
So they have to file this motion to modify, and in that same motion they need to also ask for formal custody of the child, because obviously if the parent has formal legal custody of the child, a child support order cannot be set against them. Slide, please. Other than modifying child support, another big area in Maryland, at least, is a driver's license suspension. Of course, a license can be suspended for a variety of reasons, DUI, DWIs, too many points, fake IDs. But a big factor is also non-payment of child support. In Maryland, if the parent is 60 days late, the Department of Motor Vehicles can be notified to suspend the license. And the suspension can be delayed, or if it has already happened, the license can be reinstated for a list of factors, and that is if the parent needs a license to work. Now, most of the times, if that's the case, the Office of Child Support may issue a work-restricted license instead. Or the parent is disabled and has proof of his or her disability and cannot work and cannot pay child support. Or the parent needs.
Turn it off when it's over.
Or the parent.
Okay, be careful.
The parent needs a license to comply with a court order, or the parent has either paid off the arrears in full or has been current for the past 6 months in current child support payments, this showing good faith effort. Next slide, please. As I mentioned earlier, however, a big chunk of my practice is devoted to arrears. As I said, especially when very frequently with previously incarcerated people, when they come out of incarceration, they have a really large amount of child support debt, and that causes a whole series of problems ranging from, as I said, driver's license suspension to reporting to the credit bureaus, interception of tax refunds, interception of the stimulus check, passport denial, a whole variety of consequences. So it's very important for them to see if the Office of Child Support can work with them and reduce the amount that they owe. I know that not all states are willing to do this. For example, Pennsylvania does not settle arrears at all, but Maryland's fortunate enough. We're fortunate enough that some settlement leeway is available. Child support arrears can be of two types. They can be either owed to the custodial parent, or they can be owed to the state, as Karen pointed out. Whenever the custodial parent seeks public benefits, then she will have to assign her rights to child support to the state. So whatever is owed to the custodial parent can only be forgiven by the custodial parent, and I have also noticed that sometimes they are willing to forgive as long as the non-custodial parent begins or resumes paying current child support. But the agreement has to be obviously voluntary, has to be in writing, has to be notarized, and has to be accompanied by a photocopy of the mom's ID.
Layla, there's a question on the floor here. Unassigned arrears versus assigned arrears, is there a difference, or is that a question?
Well, terminology, I think, varies, but I think assigned arrears means that they're assigned to the state.
Okay. Okay, well...
okay, well then, let's see, for next slide, please. Arrears owed to the state. Now, Maryland has placed, actually, these are, part of them, part of what I'm going to say is statutory based, and part of it is just based on the policies of the agency itself. But the state, the Office of Child Support, may agree to settle for less if certain conditions apply. Now, the first one that you see is basically a sure shot way of getting the state to reduce their arrears, and that is basically when the child has been living with and has been supported by the non-custodial parent for at least the past 12 months. And the non-custodial parent also has to have an income that's below 225% of the federal poverty guidelines. If all those three conditions apply, many times the Office of Child Support will agree to settle for a lesser amount of arrears. The following factors, are more discretionary. Sometimes settlements do occur, sometimes they don't. So, for example, if the non-custodial parent was either incarcerated, unemployed, or lived with a child when the arrears were accumulating, or the non-custodial parent is presently disabled and cannot work and has sufficient documentation to prove that. And finally, when the non-custodial parent is right now living with the child, even if it has been less than 12 months.
There's a question from Greg. He says, it seems, are you there, Greg?
I am.
Go ahead, ask the question.
Well, I'm just basically asking, is there a difference when it's assigned to the state to repay TANF as opposed to being assigned to the state to repay Medicaid? And are you seeing more of this Medicaid reimbursement?
There shouldn't be a difference, no.
Okay.
Not when it comes down to settling arrears. Okay, because many times it's either TANF or sometimes it's a foster care system. For example, the child has been in foster care for a period of time. For whatever reason, whenever basically the state does some services either to the child or because of a parent or to the custodial parent, they will assign child support to the state.
Is it the same agency then? Your TANF agency and your Medicaid, it's in the same place?
I'm on the line taking the test.
Sorry, what did you say?
Is your TANF agency and your Medicaid agency in Maryland, are they both housed in the same place?
I think so, yes.
Right.
But I'm not positive. I think it's the Department of Social Services, yes.
Right.
But as far as child support is concerned, it doesn't make a difference. Yes, okay, the final slide. Yeah, aside from what I've just spoken, there's also a new program that the legislator has passed into law recently, actually has become effective on June 1st of this year. And it's called the Child Support Payment Incentive Program, whereby if the non-custodial parent makes 12 consecutive child support payments, the state-owed arrears will be reduced by 50%. And if the parent makes 24 consecutive child support payments, the arrears will be completely erased. Again, for the parent to qualify, the arrears have to be owed to the state. He or she must have an income below a certain level that's 225% of federal poverty guidelines. Basically, if the parent can qualify for food stamps, the parent can qualify for this program. And also, he or she has 3 chances to do this program. After the third chance, after the third strike, he's out. But it's a new program, and as far as I know, it's not yet implemented, but I will push that it will, because it's on the law books, so has to start being implemented as soon as possible. And that ends my presentation. And does anyone have questions or?
I have a question.
Sure.
How does a parent file for a reduction in child support from prison?
In Maryland, it's just by filing a motion to modify child support.
Same in Indiana.
Sorry?
That's the same in Indiana.
Yeah, yeah. They can file a, pro se. In Maryland, there is an organization that helps already incarcerated parents to file that. I don't know elsewhere how it works, but
some states have a real outreach effort going on with their prisons, and they'll
Right.
have a DVD playing in the background that talks about child support and how to modify those orders and so forth. So it'll depend on the state, of course, but we have some of those materials available to share. But it's still, but Layla, how long would you say it takes a review and modification to be processed?
in the courts,
yeah, for what would you say?
in Maryland, it would be about a year.
Yeah, there's a.
I mean, in Baltimore City, yes.
Yeah, it's a long time.
It is a long time.
By regulation, they're allowed 180 days, which is 6 months. A lot of debt can accrue during that time. So there are states that are hard at work at trying to find ways to modify an order, you know, streamline that whole modification process. Again, if mom is part of the picture, you know, if you can, a lot of this is involved with crowded court dockets. It involves, you know, serving people, service of process, giving them 30 days to respond and get the information, and the other party has 30 days. If you can get parents on the same page, a lot of that time can be cut. Of course, it depends on the child support agency and if they've taken those steps to streamline the modification process.
Right.
I have a question, Layla. This is Daphne from New York State. In regards to parents that are incarcerated, there's a situation here in our state where both parents are not in the home, not in the home. One's incarcerated, one's in the military.
Okay.
DSS decided to go after the mom, who was in the military, for the child support. Once the father is released, will he be, because he already has the child support case open, will he be, do they go after both parents for child support, or they just continue to go after the mother?
No, it depends also on who has the child.
The grandmothers have joint custody.
Yeah, they can have, go after both parents.
In child welfare, that's very typical. They'll automatically go after mother as well as father.
Yeah. Yeah, if neither parent has custody of the child, then both are have to pay child support.
Okay, thank you.
You're welcome.
I have a question. My name is Stephen, calling from Cincinnati. I've been deeply enmeshed in this whole reentry and child support problem for several years, and seeing the need for change. I'm curious. I understand that the changes Layla, you mentioned in Maryland, particularly the child support incentive program, I think.
Yes.
That was a recent change, and
right.
I think I even spoke with somebody from Justice Maryland, an organization there that helped advocate for that program.
Public Justice?
Maybe that was it. Public
Okay.
Justice Maryland. I'm not sure. It was an organization that was working with people, incarcerated people, I believe, or a reentry population. I'm just curious to the extent you have any insight on the public policy advocacy piece of this.
Well, it was pushed, well, first of all, legal aid, because of LSC restrictions, we cannot lobby.
Sure.
And we cannot do class actions either. But in order for us to testify in anything, we have to be invited.
Yeah.
And so another nonprofit had invited legal aid to testify in this. It was my predecessor, so
Hey, Layla.
Yes?
This is Melissa Broom from the Job Opportunities Task Force.
Oh, yes. Okay. Right.
Hi.
So that was yes.
So we actually are the one of the groups that sort of we're we do public policy at the state level, so we were heavily involved in the bill. It took 2 years to get passed, and like Layla said, her predecessor, Keisha Brown, was very helpful in coming down and testifying in our state capitol. You know, so we are excited about the program. It passed in the legislature in 2007, but it didn't. It wasn't to go into effect until June 1st.
2008, but it hasn't even.
Right.
You know,
well, it's kind of we're working with the Child Support Enforcement Agency very closely right now to make sure that it is rolling out and that people are aware that it's even available to them, and that's part of our job is going to be to help publicize this so that people know to ask to apply for it.
And could I get your information? I'm sorry. What's the name of your organization?
It's Melissa Broome, B-R-O-O-M-E.
Okay.
And I'm with the Job Opportunities Task Force.
And that's a freestanding
it's an
nonprofit?
Independent, an independent nonprofit, nonpartisan. And my email is just melissa@jotf.org.
Okay. Thank you.
Just send me an email and we can talk off.
Yeah, great.
Sure.
Thanks, Melissa. That's great.
Sure.
Another question for either Karen or Layla?
Yeah, I've got a question.
Go ahead.
Could I get clarification on what is the Bradley Amendment again? I missed that part in the beginning. I think it was for the first amendment.
Yeah, the Bradley Amendment came about, and I think it's in the early 80s, very early 80s, and what it says is you can't forgive child support debt retroactively. So in other words, and we were also happy when that law came about, but now it's worked its way into this nightmarish situation.
Right.
And it was set up because, again, large child support debt was accruing. Guys were not paying their child support, leaving families destitute. And then when we would finally catch up with them and get them into court, the judge would just look at it and say, well, you can't pay $30,000. Let's just forget that. And you know what, your order's too high. Let's just make it $50. And and pay that, and it'll be fine. Well, he wouldn't pay it, and he would leave again. And in the meantime, obligor has the ability to buy and sell houses and own property, and really, there was very little to have any kind of leverage to get him to pay child support. So the Bradley Amendment was good in that it really held his feet to the fire, and would not allow them to walk away from their families. Again, this was a time when we were talking child support was basically divorce situations, where out-of-wedlock birth rate was not where it is today. And so these were, marriages that broke up where one parent was leaving behind financial obligations. So it was a somewhat different landscape back then.
Thanks for the clarification.
Rhonda asks a question. She says, is there a form that inmates can use to initiate a motion for modification?
Where's Rhonda from?
I don't know for sure.
It varies from state to state. There is, at least in Maryland, if you go to the judiciary webpage, and I suppose every judiciary webpage has this, pro se forms, and under the family law forms, there should be a form entitled Motion to Modify that, unrepresented litigants can use. So that would be the form that I would recommend anyone use. But
go ahead.
No, I'm just saying it just varies from state to state, so there isn't one single form that the entire state can use.
In Ohio, I'll say, and this may be true in other states, it's fairly significant whether the difference between applying for that modification with the court, whether it's the juvenile court or the domestic relations court, versus applying for the modification with the child support agency. They're two totally different entities. They have different rules on what they can modify, what they can't modify, and there are different kind of vibes, I guess is the best way to say it. The court being much more stern and the agency being much more flexible, at least in Ohio.
Well, in Maryland, the order, it always starts with a a court order, and only through the court can the order be modified. So they can talk to the Office of Child Support beforehand and say, look, I lost my job, whatnot, and they may agree, the office may agree to a lower level, but in the end it has to go through the court.
I wonder, too, though, if this might have to do with the difference between 4D, Title 4D of the Social Security Act, child support, what we call a child support case, versus a private child support matter, where you don't, for it to be a 4D case, the mother has to go in and apply for child support enforcement services. That may be at play in your particular situation, where the private is held in a different venue than the non-4D. I don't know. I'm just thinking that might be a difference.
For the study of social.
And that's the case in Indiana. It's two different places.
Yeah. Okay. Thanks, Greg.
Greg, ask your question about the service or the how do we.
In Maryland, when you are giving service, on the modification, do you have to serve the mother? Is there what is counted as service? We're kind of going through that now. Does it have to be just a letter in the mail?
Yeah, I have
to have an extra sheriff actually get a signature.
No, well, if it's a motion to modify on a case that has already been in the court, then no, it just has to be mailed.
Okay, good. Thank you.
You're welcome.
I have a couple more questions. Let me see what I'm sorry, I lost the question I had here. One question: how do courts arrest fathers who are in arrears on child support, and doesn't this violate the U.S. Constitution? The question came about from, like, you can't be thrown in jail because of other kinds of debt, but you can for arrearages and child support.
Is this for me?
Yeah, I guess so.
Child support is viewed as a judgment rather than a debt.
Okay.
So the difference is very technical, but basically, because it's a judgment, the court can find you in contempt of not paying the judgment. But basically, what has to happen, at least here in Maryland, is that, say, for example, the non-custodial parent hasn't been paying. Then he receives a notice to show up in court for a contempt hearing. If the court finds that the parent is not paying but is able to pay, then the court can find him in civil contempt and place him to jail until the parent, coughs up some money. However, if the parent is unable to pay, then the court cannot put him in jail.
I'd like to just chime in briefly. It's worse than even that. In Ohio, for instance, it's a felony if you fall far enough behind in your child support.
Oh, that's crazy.
You can be incarcerated. You can be locked up for a child support contempt, which they call a civil punishment, and then later be charged with a felony for the exact same period of time, and it's not considered double jeopardy because it's, the civil contempt is not criminal punishment. And so you can be actually incarcerated twice for the same failure to pay.
And it's a felony?
And it's a felony. This is if you fall 6 months behind. If you're up over 6 months behind, you can be indicted.
That is absolutely insane.
It is, and we're topping out 50,000 people
only over
in our
$5,000. It's a felony.
But I'm sorry, what?
In Missouri, it's a felony over $5,000 if you're behind.
Yeah, and in Ohio it's based on time. But yeah, I imagine other states. I'm curious to know if there's other states that actually have criminal provisions for failure to pay, and how that interacts with the civil contempt, because both of those mechanisms for punishment interact with each other.
No, we don't. For us, it's not a felony. No,
yeah.
Not at all.
Count your lucky stars.
Yeah. Thank heavens.
I have one question from Gene. It says, is full-time employment required before wages to pay arrearages are garnished, or does part-time wage apply?
Part-time wage applies. Any wage applies, as long as there's a wage. So if he's working full-time, a full-time check would be $500. You would take the child support out of the $500. If he's working part-time, you would take the order out, you would have to allocate it so that you didn't hit the CCPA limits. But yeah, even part-time work counts.
Okay. What I'm going to do now, we're at the top of our hour. We've passed our hour. I just want to present a couple things. First of all, there should be an evaluation sent to you, those who have participated. I really would appreciate if you go to that website, fill out the evaluation. It takes 3 minutes, and that way we can keep these webinars going. So there's the link for it. If that should work, but if it doesn't, I might send it to you in another method. But I really want you to take that evaluation. And then the second thing is, here's our contact information. So maybe if you want to jot this down, or you can write to me, and I can certainly get in contact with, I can send you Karen or Layla. Oops, that's a terrible color. Karen or Layla's email address. Just color it off. Anyway, I was trying to type my email, but it has a terrible color. Let me try to change that color.
Highlight color, Drew.
Yeah, really. That was dreadful. Let me try again.
I can see it.
Yeah.
And yeah, I can barely make it out.
Yellow.
Oh, well. Anyway, I'm D. Carberry, D-C-A-R-B-E-R-R-Y. I'm at ncpc.org. And I can get the slide presentation to you if you want the PowerPoint file on that. We can do that. But I wanted you to have Layla and Karen's emails if you had a specific question, because we had a number of questions I couldn't get to. Karen and Layla will stay on the line for a minute or two. If there's some other questions you want to ask, we'll do that. Otherwise, I'm just going to thank them and thank you for participating. We'll be here for a minute to do that. But I just want to thank you for participating. Please do the evaluation, and we'll try it again next time. If there's a question, go ahead.
Has anybody, this is Raquel Olivo with Legal Aid out in Michigan, has anybody dealt with paternity issues when there's already child support arrears?
How do you mean?
Well, yeah, how do you mean?
Like I have a client who has child support arrears. The child's about 2 or 3. And he's like, well, I'm not the father. I don't believe I'm the father. And I think he alleges there's some service problems. There are some service issues, but, I mean, there's already arrears accrued. And I'm wondering, I mean...
I'll tell you what, this happened. One case that we just have here, it's kind of the opposite, but we had a client who did not think he was a father. The child's 5 years old. So the person who was named as the father in the welfare case, when he got out of prison when the child was 5 years old, the paternity test, it's not his. All the arrearage has been transferred to the actual father 5 years later.
Oh, okay.
So we're in process of dealing with that one now.
So that was changed. How do you find the actual father?
And that can vary from state to state. When they find out that, well, you know, people can ask for genetic tests.
Right.
They should do that if they have any kind of doubt at all. But when a woman comes in for welfare, for example, she has to cooperate with child support. She'll name a father. And we have heard of women that will name somebody that they know is incarcerated because they feel, well, there's nothing you can do to him. He can't get child support. I don't know how widespread that is, but should not be establishing paternity just on that alone. There has to be a genetic test and.
See, but over here, they can be defaulted.
Yeah, in our case, there's been no genetic test. I mean, the client does have sickle cell.
I just hate to hear a default.
I know the client and the child has sickle cell.
Oh dear.
We've not had a test yet. I mean, we're going to. I mean, the client's probably not going to go through it because he'll have to pay for it. You see.
Yeah.
And so he's not wanting to push it too hard. But there was not a test. They did.
I can't speak to default paternity that much. I was told it's sort of rare.
There
must have been a lot of extenuating circumstances. They must have been, you know, living together as a couple. There must have been something that gave the court.
Both men were in prison. She just named the wrong one. And when he got out, he said, "That's not my. You mean I owe this child support? That's not my kid."
Yeah.
He took the paternity test. It's not his. The child came back with sickle cell. showed up at the house and said, "This has got to be your kid." That's exactly what happened. So now that, and then about a week later, we got a letter from the child support office that they wanted to. They're in the process now of what I assume is transferring the arrearage. That's what we assume has happened. We've not gone to court yet, so we're not sure. But we know, we assume that's what's going to happen.
Boy, oh boy, you know, you could talk all day about paternity. That in and of itself is.
Here, that's a huge issue because it's not any kind of extenuating circumstances. As long as they're serviced, and you know whether they got it or not, as long as they supposedly were served, that's it. If they didn't respond, they're defaulted.
Yeah.
Too bad.
And that service of process is so iffy. You know, people can have so many addresses, and you know how often that service of process is hitting its mark. I don't know.
You're raising an interesting point for our case. We got to find out if the fellow was served.
Right. That's the one thing that we attack if we can, is we look at the service, because that's something that we can easily go. But you know, the fact that there wasn't a DNA test, that matters not to anyone here.
Yeah.
How long is it in Michigan? How long do you got to request the DNA test?
I think easily a year. You can get, you know, if they defaulted someone, you got a year to set aside the judgment. But then after that, you're kind of at the mercy of the prosecutor.
Okay.
Or the judge.
Or the okay.
Yeah, definitely. I've seen cases where the judge orders a DNA test in cases in which the judge doesn't. There is a case in Maryland that just came down from a court of appeals denying a father who, a father who had a vasectomy. Then 4 years later, the wife gave birth to a child, and 13 years later, he contested paternity, and the court didn't allow that.
Well, they didn't.
Wow.
No.
Probably because he had a relationship.
Yeah. 13 years is a long time, and he held himself out to be the father, and he didn't want to terminate parental rights anyways. He just didn't want to pay child support. So the court in that case said no, but that was 13 years, and he should have known because he had a vasectomy. So chances are the child isn't his. But so in that case, it was completely a benefit, you know, a best interest of the child standard.
And this is true. On our website called the Intergovernmental Referral Guide, the IRG. And when you go to our homepage on OCSC on that slide that he gives out, if you look for that Intergovernmental Referral Guide and click on that, you'll find state maps, and it contains the state profile of every state. So that by that I mean it just gives you a thumbnail sketch of how child support is administered in that state, and it talks about things like the statute of limitations, age of majority, paternity, how income withholding, all of those kinds of things, about 10 or 11 different aspects of child support and how it's carried out. So
what website is that?
It's on our ACF website, so it's OCSC.acf like Frank, .hhs like Sam, .gov. If you go to that main page, and you'll see, and then it's also /programs/CSE